I believe we have everyone here now. We're going to go on the record in the matter of Andrew Moon et al. Versus the City of Northwildwood et al. It is Cape May docket number CPM-L-443-22. Can I have the appearances of the parties, starting with the plaintiff?
Good morning, Your Honor. Oliver Berry from the law firm Berry, J.S.C. on behalf of the proposed class. I'm also joined by co-counsel from my office who I'll introduce yourself.
Good morning, Your Honor. Shauna Friedman, also from Berry, J.S.C., also on behalf of the proposed class of plaintiffs.
Good morning, Your Honor. Luke Breslin from Jackson Lewis on behalf of the City of North Wildwood and Scott Jett.
Mr. Sosis, you got to unmute.
Sorry about that, Your Honor. Your Honor, this is Bill Sosis on behalf of the defendant, Inside Intelligence, a.k.a. OPRAmachine.
Okay, I want to deal with Mr. Sosis's motion for reconsideration first, and then we'll do the motion to dismiss a claim on behalf of the city and its individual defendants. And initially, this is a motion for reconsideration filed by Mr. Sosis on behalf of his client, and this is a motion for reconsideration of an interlocutory order. And the court finds that Rule 4:42-2 applies, 42B applies. It is the interest of justice standard under Lawson versus DeWar, 468 New Jersey Super 128, the 2021 Activision case that sets that standard. I want to initially indicate, in reviewing the original motion papers that were filed, the court found, under the very liberal standard that we're constrained to under 462E motions, that accepting the allegations as contained in the plaintiff's complaint, and really specifically the allegations that were on clause 37, indicating, and that not limited to 37, but that Insight Intelligence LLC and Gavin Rossi knowingly and fraudulently misrepresented that it would maintain adequate data, privacy, and security practices and procedures to safeguard plaintiff's data, social security numbers, and personal identifiers from unauthorized disclosure, release, data leak, and theft. And it goes on in that count, inferring that this wasn't a pass-through website, that they had control over the content, some control over the content, and what would be posted and what would not be posted, and therefore the DCA wouldn't grant it immunity. And counsel for the defendant, Mr. Sosis, cited a number of cases and indicates that we have to look beyond that. And I disagreed and denied the motion. We now have a motion for reconsideration, and Mr. Sosis has changed the game a little bit, because in his original moving papers, counsel provided a brief certification from his client, Mr. Rossi, that indicated, hey, I'm just the owner and I have an LLC, and I got an LLC because I didn't want to have personal exposure, and I didn't do anything outside the scope of my company, and therefore I should get out individually. And that does not combat the allegations contained in plaintiff's complaint, indicating that this is not a pass-through, and I'm using the term pass-through, I think everybody understands what that means, that it's a not a pass-through website, that they control the content somehow and decide what's going to be posted and not going to be posted. But now, Mr. Sosis changes that because he's now added to the motion for reconsideration by attaching a new certification of Gavin Rossi that's 3 pages long, and he also contains the OPRAmachine terms of service that he would like the court to consider. And understanding that on a motion for reconsideration under Rule 4:42-2B, the court is not constrained in its reconsideration by the original record. And that is the New Jersey Supreme Court case of Lombardi versus Masso, 270 New Jersey, 517 at 537, a Supreme Court case from 2011. And that certification is potentially a game changer, because that cert, if true, establishes that the OPRAmachine website is a pass-through, that they have no control whatsoever about what goes up on the website.
Yeah.
Hold on.
Your Honor, I'm really sorry to interrupt. Oliver Berry's in the waiting room. He just got kicked out again. I apologize. He's only been out for about 10 seconds.
Okay. Let me see if I can get him rebate.
Looks like he's coming back in.
Okay.
I'm very sorry.
No, that's okay. I'm glad you
I'm
did.
sorry, Your Honor. My desktop crashed. I had a backup laptop, and then that crashed. My apologies.
No, Mr. Berry, I indicated that Mr. Sosa has provided a new certification from his client, Gavin Rossi, and he also attached to the motion for reconsideration the OPRAmachine terms of service, and that especially Rossi's certification combats what you're indicating in your complaint. And the court's analysis in the original motion was, if those allegations, those facts were proven true, then the plaintiff's website is not a simple pass-through website, and then the CDA, federal law, doesn't give him immunity. Okay, but he's changed that now. He's indicated in this new motion that the OPRAmachine software automatically processes the responses and uploads any attached documents to the website, making them publicly accessible. That the automatic publication process occurs without any intervention or control by the website's administrators or operators. And that is from Mr. Rossi's certification. That is now not a motion under 46.2e that would limit the court to the 4 corners of your complaint, and it looks at those with great deference, and we search those really looking to glean a cause of action and accepting that is true. And that's the standard, and it's a liberal standard. If, though, the court is to accept matters outside the pleading, and that is, and again I'm going to read from Rule 4:6-2, if on a motion to dismiss based on defense E, matters outside the pleading are presented to and not excluded by the court, the motion shall be treated as one for summary judgment, and disposed of as provided by Rule 4:46. And all parties shall be given reasonable notice of the court's intention to treat the motion as one for summary judgment, and a reasonable opportunity to present all material pertinent to such a motion. The Supreme Court says that the court's not constrained in a motion for reconsideration to the original record. So the court's permitted to look at Mr. Rossi's new certification and the terms of service that his company provides to the users, which are attached to the exhibit, and what the motion is, the gist of the motion is that these combat the plaintiff's factual allegations in the complaint, and it is a pass-through, and therefore we're immune under the federal statute. It is going to be the court's intention to consider those papers. I think in the interest of justice that I'm compelled to look at Mr. Rossi's certification and the service terms. And most importantly, for the motion, I think it's the certification of Mr. Rossi. Mr. Barry, do you want additional time, a reasonable time? And I don't know how you would do that, quite frankly, at this stage of the game. Do you want more time to present to the court any materials that you think are pertinent to my review in light of Mr. Rossi's certification? I'll grant you that time if you need it. But I'm going to decide this motion under the summary judgment standard, and I am going to consider this new certification and the new evidence they've presented.
Your Honor, my thoughts on that are twofold. So initially, one is a legal issue that sort of underpinned this, but has yet to really surface because as much of these arguments are, as Your Honor knows, these are really summary judgment arguments appropriate on an actual record, which at this juncture we do not have because there's no discovery. And that is that, though again, this is something that is yet to be fully explored through discovery, that the functioning as we understand it of this website service is distinct from all of the pass-through entities, forums, or search engines that appear in many of the case law cited by all of the parties, in that, though at the direction of someone retaining its services, it makes the request itself for information that is then posted to it. Though it is third-party information and public documents, it's, as the name suggests, OPRAmachine, it affirmatively seeks out, and then displays particular information, which I think is a distinction that is not really fully explored in any of the case law I've seen analyzing the CDA, and something that I think is only appropriate on a full record. Secondarily, I think under, as Your Honor and the Lawson case notes, which again I agree is the correct standard, I can indicate that there was no intention to deceive in citing to the prior standard.
I'm not finding there's any. I'm not finding that.
No, I know. I just noted it wasn't explicitly stated in some of the briefings. But if Your Honor is to convert this into a motion for summary judgment by virtue of inclusion of documentation outside the pleadings, well, I think the response is easy. It's to deny it as premature.
Let me stop a second. And I understand that this certification is a self-serving document. Okay? But if it's true, and he's certifying that it's true, then his company has no control whatsoever about what it posts. That when the city answers the OPRA request, it goes to his website, it automatically gets uploaded without any filter. See, I could see in your complaint indicating they make representations. They've got a filter. And look, I am not a IT genius by any means. But if you've got a filter, and just like a spam filter on your computer, and you set it to indicate Social Security numbers, and that triggers it where it doesn't load those, and then it's reviewed by somebody from the company, and they say, okay, that's not Social Security, we're going to load that. Or wait, this is Social Security, we're not going to load that. That's different. And I don't think that that's a pass-through company, okay, that gives them immunity under the CDA. Mr. Sosi might disagree with that, but that's my interpretation of that. But the certification says that that's not accurate. We don't do any of that. It is literally a pass-through. It is, we're getting the information, the request, we're passing it on, and then it gets automatically uploaded. If that's true, they're not in the case. I think you'd agree with that. That if that's actually true, then the allegations that I had to accept as true in your motion wouldn't be true. And they would get out on summary judgment. And I know that you're saying, hey, let me conduct discovery and we'll see if let me test that. But isn't the same thing accomplished if I grant the motion for reconsideration and dismiss the company without prejudice?
Your Honor,
hold on, let me finish.
I'm sorry.
If you dismiss it without prejudice, okay, if you then you're still entitled to take Mr. I'm going to say that right, Mr. Rozzi's, I hope it is, Rozzi's deposition. He's a New Jersey guy, and you can take his deposition. You can subpoena him to be deposed. If you find out that somehow that what he is certifying is not accurate, you can make a motion, because it's still not an order that disposes of all parties. It's still going to be a motion of an interlocutory order that in the interest of justice I can modify until the case is over. But why should Mr. Rossi's company have to take everybody else's deposition, have his attorney sit through all those steps and pay them all if this is true? And isn't that the better course? Unless you've got something in your file that you want the court to consider, and I'm going to give you the time to do that. But I'm assuming that you probably don't at this juncture.
Your Honor, I was actually going to suggest, hearing your comments and sort of reasoning, that because of the absence of discovery, I don't think I would ask for more time, because I would need that discovery really largely to provide something to the court to contest the information provided at this juncture. I was going to suggest only based on the same reasoning Your Honor submitted, any order be without prejudice, though I suppose that's a point of, as it would dispose of any final, the case finally, I guess a point of perhaps moot. I was going to suggest something similar here in Your Honor's line of reasoning, that, again, based on the legal distinction I raised, that is additionally and separate to this consideration of whether it has any safeguards, I think the functioning of the website puts it in a category functionally distinct that's not quite been addressed. But that issue aside, it's hard to evaluate these kind of things without a factual record. So I would ask only that any dismissal be without prejudice, and should there be anything that changes in discovery, we can certainly raise it.
Well, I think that's the better course. I mean, it looks like defendant is an interactive computer service provided because of this cert, as defined by 47 U.S.C. Section 230 F2, and that under E3, no cause of action may be brought and no liability may be imposed under any state or local law that's inconsistent with this section. So if he is an interactive computer science service provider, which was in question before I get this certification, the only other issue I had, and it's a legal one, was that Section E3 is where you get immunity, but E4 indicates it doesn't limit the application of the Electronic Communications Privacy Act of 1986 or any of the amendments made by such act or any similar state law, which I think carves out an exception to the liability. But my review of the Electronic Communications Privacy Act really deals with wiretapping.
That's my understanding as well, Your Honor.
Okay.
I would note only that the definition section talks about information content providers as any person that is responsible for and part of the creation or development of the information. And though it is third-party information, and as pointed out, there is a line of cases indicating that doesn't count, that's what third-party information is voluntarily posted. I think this is a bit different, but again, I don't have a factual record to submit to the court to evaluate these nuanced issues. So I hear what Your Honor is saying. I would submit only that any dismissal will be without prejudice because I think these, quite honestly, very interesting nuanced legal issues will require and will develop factual record to dispose of with any finality.
Your Honor, I would like to be heard when possible.
Sure. You're winning right now, Mr. Sosa.
I understand, and I know the rule that you never interfere. You never disrupt the judge when he's on your side. I totally get it. I just wanted to say that I thought, not to disagree with the court, but that the original motion did include the arguments that we're talking about. It's specifically Section 230 under the Communications Decency Act, and all the standing requirements under the Consumer Fraud Act, which is specifically count 2 in the complaint, which is the only count that pertains to my client, and that all the standing requirements there were not met. And also that as you know, they're seeking injunctive relief and damages for what they consider violations of the Consumer Fraud Act. And they base these claims entirely on a single piece of third-party content that was uploaded in response to an open public records request by the city of Northwildwood, which is specifically talked about under the Communications Decency Act, that this is one of the requirements that the court has to look at, whether we're talking about a piece of content, information content that was uploaded by a third party. So I won't add anything because I like what Your Honor is saying, and I totally agree. So I just want to say that, there's really no, as a matter of law, there's no claim here, like I said originally.
But I think the difference in the court's mind is that was your client a pass-through? Not under the allegations. It's not under the allegations in the complaint. You argued that it was. You argued that it was a pass-through, and therefore the DCA applies, and all this case law is applicable. But if I believe and I accept as true, and I know you harp on that in your reply, in your brief for reconsideration, that's the standard. That the court is constrained to look at the four corners of the complaint and nothing else. Okay? And if I'm looking at that complaint, is there a cause of action? Yes, because under the complaint itself, as alleged, your client isn't a pass-through. that they have affirmative action in that third. It's not just that third party puts it and it automatically goes up the website. That's not what they alleged. And until I got the cert says it is a pass-through. It's clearly a pass-through. That's what that cert that you attach to your motion for reconsideration says. That changes in the court's mind what I accept is true in this. And it changes what I'm looking at, because I'm now looking at something outside the four corners of the report, and unless the plaintiff can come up with something that says that's not accurate, then I think I grant the motion. That's the difference. It's not your analysis. I think your analysis was correct in both the motion and the motion for consideration. The difference is Rossi's certification. The difference in the cert. The first one is just like, hey, I'm a limited liability company, which I agree with, and that's why we let him out. That's why he's not a limited liability company. But he didn't say anything about, hey, I'm a pass-through. I'm a true, in every sense of the word, a pass-through website, which you get immunity for in this situation. That's the difference in the court's mind. But you're right, you're winning. I am going to let them out, the defendant out. I'm going to grant the motion for reconsideration. I am going to dismiss it without prejudice. And then what I would say, Mr. Barry and Mr. Sosis, is when discovery's over, Mr. Barry, you can communicate with Mr. Sosis. Obviously, if you don't have anything, you're not going to bring him back in. And then you can just do a consent order dismissing it with prejudice. Is that okay?
Well, yeah, I hear Your Honor's direction. Again, I had our position disagree that is, I guess, the appropriate course, but I can certainly follow that direction, and we'll see how discovery proceeds, and be guided accordingly. I would only note or ask, before we move on to the Northwildwood motion, would the court like myself or co-counsel to address the myriad of ethical allegations made in the underlying motions on behalf of OPRAmachine? I just noted that there was assertions that we were intentionally misrepresenting the law.
No. Look,
I didn't feel the need to, but I just wanted there to be a note in case there's any questions Your Honor had.
I don't have any issue with that at all. I mean, and that's it. I mean, I don't really have anything else to add in terms of the motion for reconsideration. So I'm going to enter an order. I may not upload that today, Mr. Sosis, just because I've got a lot of motions. I had 60 motions on for Friday that we couldn't get to Friday. We have moved them throughout this week. I will endeavor to get it done, but I did an MOD and I want to review it. But that's going to be the order of the court, that it's going to be dismissed without prejudice against Insight Intelligence LLC, doing business as OPRAmachine.com. Okay? Mr. Joseph, you can certainly stick around if you'd like to and listen to the other argument, but you don't have to.
I would like to, Your Honor, if that's okay. I would like to listen to the other argument.
Sure.
If that's fine with the court.
Okay, yes, it is. All right, we are now moving on to the defendant, City of Wildwood's motion to dismiss the complaint for failure to state a claim under 462E. And we've got, Mr. President, your motion, sir.
Thank you, Your Honor. May it please the court, As you mentioned, my name is Luke Breslin from Jackson Lewis on behalf of the City of North Wildwood and Scott Jett. Briefly, I just want to recite the allegations and some facts for the record here. On June 8, 2022, an individual made an open request to the City of North Wildwood requesting updated recertification civil service list for the City of North Wildwood Fire Department. On June 10th, in response to that request, Mr. Jett, the city clerk in North Wildwood, uploaded a document to OPRAmachine.com, the website which received the open request. The document was generated by the New Jersey Civil Service Commission Division of Classification and Personnel Management and contained the names and addresses and unredacted Social Security numbers of 88 individuals. On March 4th, approximately 53 days later, the City of North Wildwood was notified that unredacted Social Security numbers were uploaded to OPRAmachine. Those documents were immediately removed from OPRAmachine. Plaintiffs concede that the information was removed from the OPRAmachine website. On May 25th, the City of North Wildwood sent a letter to each of the individuals whose names were listed on that document, informing them that their Social Security numbers were inadvertently published. Additionally, they sent a letter to the individuals informing them and providing them an opportunity to sign up for Norton's LifeLock, which provides identity theft monitoring services free of charge for a period of 2 years. To date, none of the named plaintiffs have taken advantage of that offer to utilize the Norton LifeLock service to prevent any potential identity theft threats. Subsequently, on November 16th, plaintiffs filed the present three-count complaint asserting claims under the New Jersey Consumer Fraud Act against my client, City of North Wildwood, and Mr. Jett, as well as a claim under the New Jersey Civil Rights Act against my clients. I'll discuss in some more detail. My client cannot be held liable under Count 1 or Count 3 of the complaint as a matter of law for the temporary inadvertent disclosure of Social Security numbers in response to an open request. In furtherance of my argument today, we'll be relying on our papers, which I think succinctly set forth our position with respect to these issues. Briefly, and I don't want to overstate what we put in the papers, but as the court is well aware, the motion is to dismiss standard requires the court to requires the court to examine the legal sufficiency of the complaint, meaning the court must search the complaint in depth with liberality to see if there's any legal basis for the cause of action. Dismissal is mandated when the factual allegations are insufficient to support a claim upon which relief may be granted. And as the court in Edwards v. Prudential property, the motion to dismiss should be granted even if generous reading of the allegations does not reveal a legal basis for recovery. So with that as a background, Your Honor, I'll first address the general provisions of the Consumer Fraud Act. As Mr. Sosa alluded to briefly earlier, in particular, the complaint specifically identifies sections 164 and 166 of the Consumer Fraud Act, which is also known as the New Jersey Identity Theft Protection Act. It wasn't entirely clear whether or not plaintiffs are relying on the general provisions of the Consumer Fraud Act, which have certain standing requirements and requirements to demonstrate a prima facie case, including that they're consumers as defined under the law, that they have ascertainable loss, and that the defendants engaged in unlawful practice as defined by the law. In plaintiff's opposition papers, we did not see any opposition to our moving papers that they cannot satisfy those standards. We will presume that those are unopposed, and we request the court to view them as such. Our moving papers set forth why they cannot establish those standards, but to the extent the court wants us to explain those arguments in more detail, I'm happy to do so. But given the lack of opposition, I'll presume that those are essentially waived and that plaintiffs are relying on claims under the New Jersey Identity Theft Act 161 through 166 of the law. So,
Mr. Barrow, do you agree with that? I mean, I know you've pled Consumer Fraud Act, but you're basically saying that they violated the identity fraud provision, correct?
That's correct, Judge, with the caveat that I think the injunctive request flows from both. But as to a damages claim under general the Consumer Fraud Act, I agree with Mr. Breslin. That is not what is asserted. Solely a NJCRA constitutional claim and a claim through the ITPA. So I would agree with that, Your Honor.
Okay.
Thank you. So I'll first address the claims under the New Jersey Identity Theft Protection Act. I think, again, as our papers laid out there, Section 164 of the NJITPA expressly prohibits the public posting, displaying of any individual Social Security number or any four or more consecutive numbers taken from an individual Social Security number. However, and most importantly, for purposes of this proceeding, 164 also includes an express exemption for documents that are recorded or required to be open to public pursuant to Title 47 of the revised statutes, i.e. OPRA. Those documents are not subject to the redaction requirements set forth in Section 164 of the NJITPA. As Your Honor is aware and the parties are aware, and Mr. Barry just explained, there's two claims here. There's a claim under the New Jersey Civil Rights Act, and there's a claim under the New Jersey Identity Theft Protection Act. There is no claim of a violation of OPRA in this instance. Plaintiffs do not dispute the existence of this exception under the NJITPA. Rather, they're merely claiming, without citing to any applicable legal authority, that this exception doesn't apply. They're asserting that the OPRA redaction requirements essentially override this exemption and essentially would render this exception superfluous, despite the fact that this exception was enacted by the legislature after the OPRA statute was enacted. So plaintiff's argument in opposition to our position that this exception applies and that the temporary inadvertent disclosure of Social Security numbers pursuant to an OPRA request, which was remedied nearly 53 days later, and plaintiffs were offered an opportunity to engage in the LifeLock service, should be analyzed under OPRA standard is simply incorrect.
Well, let me stop you, because the ITPA provides that, quote, nothing in this section shall apply to documents that are recorded or required to be open to the public, end quote, pursuant to the Open Public Records Act. So it's making it pursuant to the Open Public Records Act. And we agree, right, that 47(1)(a), 5A requires that a custodian redact any information to disclose the Social Security numbers, right? That's what OPRA. That's what the OPRA says, correct? That
OPRA has. Sorry, go ahead.
No,
sorry.
Isn't that what 47(1)(a), 5 small a indicates, that the custodian shall redact any information that discloses Social Security numbers?
Section 5 of OPRA also states that information that's required to be open should not be redacted. That was the analysis in the Burnett case. That's why they engaged in the balancing test and the balancing analysis under OPRA. So a determination of whether or not OPRA is violated is not an issue before the court. The issue before the court is whether or not the exception under the NJITPA applies and eliminates the redaction requirements set forth in the NJITPA. The analysis under OPRA is simply not before the court. We're limited to the claims made in this case, which are NJITPA claims, not OPRA. Plaintiffs are attempting to conflate the requirements of OPRA to those set forth in ITPA, and that's simply not accurate. The court in Burnett expressly stated that the exception under 164E is applicable. It just was not applicable in that case because there were no claims under the NJITPA. In fact, the NJITPA was not even effective at the time of the underlying claims brought in the Burnett case. It was simply an OPRA claim. So our position is that 164, the exception under 164E applies. And if we took plaintiff's argument as true, the redaction requirements of OPRA, the exception under 164 would be simply superfluous because the documents would have already been redacted, assuming we're taking arguments made by plaintiff as accurate. So that the action of the legislature to specifically include this exception, would have been unnecessary and superfluous, and simply no reason for doing so. Again, it was done after the fact that OPRA had already been implemented. So in terms of other arguments in plaintiff's opposition papers, the one argument is that the documents at issue, the civil service list, was not required to be recorded or required to be open pursuant to OPRA. That's simply inaccurate as well. The document clearly fits within the definition of a government record under OPRA. So the exception under 164E, it is our position, clearly applies in this instance. Additionally, under 166, which is the second aspect of their claim under the Consumer Fraud Act, since they're unable to prove a claim under 161 through 165, as set forth in our papers, they're unable to prove a claim or prima facie claim under 166, which requires, satisfaction of the claim under 161 through 165. So moving on, I've already mentioned the aspect about the civil service list being a government record and fitting within the definition of the 47 under exception 164E. And briefly, I know we noted, I briefly touched on the Burnett case. With respect to the claims under the Consumer Fraud Act, and we'll talk about it separately under the Civil Rights Act, as I mentioned, the claims in that case were OPRA claims. The ITPA was not even effective at the time of the underlying claims in Burnett. The Supreme Court expressly recognized the exception under 164E, under the ITPA, but specifically noted that it did not apply in that case, given that the claims were limited to OPRA claims in Burnett. Further, in terms of plaintiff's arguments and citation to other matters, these would be, I guess, more applicable to the civil rights aspect of the claim. But as to the Consumer Fraud Act claim, we essentially, plaintiff's argument that it does not apply in this case simply would not be consistent with the legislative intent of actually preparing, drafting, and enacting this provision subsequent to the effective date of OPRA. We do not, if plaintiff's argument is accepted as true, it's hard to imagine any situation when this exception would apply. The plaintiffs have clearly not articulated a situation when it would apply if it doesn't apply in this particular instance.
What do you say to that, Mr. Barry? But before we move on, what do you say to that argument, Mr. Barry?
With respect to
saying you didn't make OPRA, your claims are ITPA claims, and not OPRA claims, and therefore, why doesn't the
why do you have to look at both, Your Honor?
Well, why doesn't the 568164E exception bounce your case.
Thank you, Judge. So initially, there's no, that we are aware of, cause of action OPRA provides in this situation for unauthorized disclosure. But let's turn to this at hand. So we're not trying to conflate the two. It's merely that, as Your Honor referenced previously, you have to look at what's available under OPRA and consider the context in which these statutes were enacted applies. 864E provides, doesn't apply to records required to be open to the public pursuant to Title 47. Now, OPRA was enacted in 2001. The ITPA was enacted subsequently, but prior to Burnett in 2009. And what was an issue in Burnett was resolving the inherent conflict between 1A1 and 1A5 of Title 47. And, within that about what was to be redacted, there were two subparts, and one of them were documents that were required to be open to the public. I think, respectfully, perhaps we did not articulate it sufficiently, but we did. I respectfully submit counsel's mistaken. We're not arguing that they're not government records. The point was that whether you can, that as not documents required to be open to the public, they are required to be redacted. But even if they were, pursuant to the reasoning of Burnett, they're required to be redacted, required to have the Social Security numbers redacted. Whichever subset of the 1A5, language types of documents you fit them into, they're required to be redacted. The reason, when you look at this history of the enactment of these statutes in Burnett, that this provision exists is clear, is because at the time the ITPA was enacted, there was not clarity with respect to the redaction of Social Security numbers under certain types of government documents to be provided under OPRA, which was then addressed in 2009 by Burnett. And I can see why the legislature wouldn't have wanted to create a situation where the entity or government employee involved had to comply with one statute and thus violate another. But post-Burnett, it's unequivocally clear that these records in this form, without any redaction, are not required to be open to the public by Title 47. In fact, they're prohibited by Title 47 to be open without redaction. And that's the reason why we're pointing to Burnett and to the OPRA language, is because when you read the language of 56.8.164E, you have to look at it and determine, well, was this something that was required to be open? And generally, it's a government document that's subject to reduction under OPRA. That's not disputed. But it is not required to be open like this. It is, in fact, prohibited to be produced without the Social Security numbers. And therefore, we are in this situation where if you read it in the way defendant suggests, with the current state of the case law in New Jersey for the last 14 years now, you're left with this, I submit, an absurd situation given the scheme work of the ITPA and of OPRA, where documents that should not be produced without redaction, that this information should not have been produced, and I do think there is factual agreement in the record as to that. I don't think anyone's saying it should have been. Not permitted to be produced under OPRA. But the fact that it was inadvertently produced, which violated OPRA, even though it was not required to be open, then bars the application of the ITPA simply because it was wrongfully produced pursuant to an OPRA request. I think, and I understand the defendant's argument, I understand the language of the statute. These are, interesting questions of statutory interpretation, but that is an absurd result, Your Honor. Right? That's a result that is not what Burnett said. In fact, Burnett only referenced the ITP's application as it was trying to have guidance about how they should resolve the conflict within Title 47 between 1A1 and 1A5. they weren't making any sort of larger pronouncement about the application of these statutes or the interaction between these statutes going forward. And I think trying to read more into that, cursory comment by the court, again, gets us into this territory where accepting that interpretation would then lead to this result where documents that are not open without redaction can be wrongfully produced, and because they were submitted to an open request, even though the ultimate documents were not in that format required to be open to the public under Title 47, somehow then still bars the application of the ITPA, I submit then runs afoul of the canons of statutory interpretation, where you must look at the whole of the statute, and you cannot interpret plain language to lead to an absurd result.
Okay, let's move on to the constitutional and civil rights claims.
Your Honor, just before moving on, just make one comment in response to that. I will say that I don't believe Burnett was decided based on the facts of that case, the specific facts of that case. The court engaged in a balancing test due to the apparent conflict between 1A1 and 1A5. And they determined based on those specific facts that the documents, the Social Security numbers, should be redacted. So I don't think there's any blanket declaration that Social Security numbers need to be redacted, especially based on the express language of Section 5, 1A5. With that being said, as I've mentioned a few times today, this is a NJITPA claim. We're not dealing with OPRA. Any analysis under OPRA or the Burnett Court's balancing test is inapplicable here. We're dealing with the plain language of 164E that states that the redaction requirements set forth in the NJITPA, which are the claims asserted in this matter, do not apply to documents that should be recorded or required to be open to the public under OPRA, which in this case are civil service lists that constitute government records and fall within the definition of government records. So,
but their Social Security numbers aren't. Their personal information isn't required. In fact, it's prohibited under OPRA.
I don't believe that's an accurate statement. I believe that Burnett engaged in a balancing test to determine in that particular case the Social Security number should be redacted. In this particular case, the facts are only different, as I've talked about in the Civil Rights Act. But by deeming and the NJITPA has specific redaction requirements as to Social Security numbers, and 164E specifically states that those redaction requirements as to Social Security numbers does not apply to this specific set of documents. So unless Your Honor has more questions, I'm happy to move on to the next.
No, you can move on. I disagree with your interpretation of that, though. I don't see how you can look at one without the other. I don't agree with your interpretation of how you are looking at one only and not the other. I don't think that is what they were indicating. I don't think that's what Burnett says. I don't think that's. I mean, if I was a clerk, and I appreciate that this may have been inadvertent, but if I am not doing this inadvertent, I don't like these guys. So heck, I'm going to stick it to them, and I'm going to give them the open request and purposely, willfully, wantonly stick in all that personal information. You think I'm immune immune from the Anti-Theft Perfection Act in New Jersey?
Based on the express language of the statute, 164E would apply. To the extent they made an OPRA claim, perhaps there's a violation of OPRA, but we're dealing with two separate statutes.
I think
the analysis under OPRA is different than the analysis under NJITPA.
I don't know how you don't read them in conjunction with each other, given the fact that you're talking about these records being provided pursuant to OPRA.
Well, there's two separate statutes, and the Burnett Court specifically stated that NJITPA does not apply, is not read in conjunction with OPRA because it's a separate section, but that the exception does exist.
I didn't read it that way. I didn't read it that way. Go ahead. I'm going to reread Burnett before I actually rule on this. I'm going to reread it.
Your Honor, at the risk of saying one more thing, I think I actually can provide some clarity to our position on that, if
Sure.
the court would permit. 1A5 has two categories. First is, prior to allowing access to any government record, the custodian thereof shall redact from that record any information which discloses a Social Security number, credit card number, unlisted telephone number, or driver license number of any person. That's the first part.
That's A.
Now, Burnett dealt with the second part, because if the first part was an issue in Burnett, then it would have been no need for Burnett, it would have been resolved. Burnett dealt with the second part, which is, except that a Social Security number contained in a record required by law to be made, maintained, or kept on file by a public entity shall be disclosed when access to the document or disclosure of that information is not otherwise prohibited by law. And in Burnett, the title documents were required to be kept and recorded. That issue was subsequently addressed by another amendment, but it wasn't, didn't have a prior application. So the issue, and what I was trying to articulate earlier about the relevance of the civil service logs not being a document that was required to be made or kept, and we cite the regulations in the underlying brief, was that it's optional. It falls into that first category. While I submit, Your Honor, that even if it fell in the second category, I read Burnett and the subsequent case law, the SPCA case, to really lay out that it shall be redacted even in the second category, as well as the amendment talking about recorded documents. The thrust of that issue about why the civil service lists weren't required wasn't that they weren't government documents. It was that they fell into that first category, such that I don't even know that you need to get to Burnett. Necessarily, we addressed it because if it's in the second category, I think Burnett, pursuant to Burnett and his progeny, you have to redact Social Security numbers anyway. But because these records fall into the first category of 1A5, I think it's just definitive that they must be redacted. That was the relevance or the significance of that, and that's why I think that issue resolves the concern, even though I think Burnett would require their redaction if it was the second category. But that was the significance of that point. And my apologies if I didn't articulate that as effectively as I should have about what the significance of that was. But I have nothing further, Judge.
Okay. Let's move on to the state constitutional and civil rights claims.
Thank you, Your Honor. As laid out in our movement papers and in the slide brief, plaintiffs have not, nor can they, identify any legal authority to support their argument that the brief, temporary, inadvertent disclosure of Social Security numbers in response to an OPRA request implicates a right to privacy under the New Jersey Constitution. Plaintiffs seem to suggest the right to privacy under the New Jersey Constitution is all-encompassing, and argue that merely alleging that the unique circumstances in this case involving temporary inadvertent disclosure creates a constitutional right, and that it must be accepted as true, just based on their simple allegations, as they have not presented any legal authority to support their argument. Specifically, and I'll quote, plaintiffs' allegations that defendants made an unauthorized disclosure of sensitive personal information in the form of a Social Security number is more than sufficient to demonstrate a constitutional right of privacy in said information. So that quote alone basically says, because they made allegations, it's more than sufficient to demonstrate a constitutional right of privacy. Based on the established precedent under Printing Mart Morristown and the standard of review the pleading standards in New Jersey, that's simply insufficient to establish a legally cognizable complaint. sufficient to override any kind of motion to dismiss at this junction. As I mentioned, there is no legal authority demonstrating a right to privacy based upon the circumstances here involving a temporary inadvertent disclosure of Social Security numbers that was corrected 53 days later after the town was notified of the issue, and then subsequently the town offered the LifeLock services to plaintiffs. To the contrary, as noted in our reply papers, courts in the Third Circuit, United States District Court in New Jersey, have expressly held that the negligent, inadvertent disclosure of Social Security numbers does not give rise to a constitutionally protected right of privacy. That's Warner, Weisberg, Macaulay. Again, I will touch on Burnett for purposes of whether or not a constitutional right of privacy is implicated in these circumstances. The circumstances in Burnett are entirely distinguishable from the case being heard right now by Your Honor. Specifically, as I'm sure Your Honor recalls, Burnett involves an individual seeking 8 million documents related to real estate documents, mortgage documents. I think there were 13 different types of categories of real estate documents that were being sought. And they all contained private information, including Social Security numbers. In this case, we're dealing with a 2-page document, I believe, disclosing the Social Security number for a short, temporary, inadvertent period of time that was immediately remedied. The individual in Burnett, they were seeking the 8 million pages of documents to be used for commercial purposes and sold to the public. The circumstances there are entirely different from this situation, again, involving a temporary inadvertent disclosure. In particular, the court in Burnett, in finding that the OPRA redaction requirements did apply, noted that based on the large number of documents, this is a wholesale disclosure of Social Security number through OPRA requests for masses of documents, of recorded realty documents. They based upon those circumstances, determined that the OPRA redaction requirements apply. I will say that in plaintiff's opposition papers, they argue that a constitutional right to privacy is recognized by the Burnett Court, except they cite to the appellate division case. The Supreme Court, which subsequently reviewed the appellate division's analysis of the claims, expressly held that they did not make a finding on the question of whether a constitutionally protected right of privacy was implicated in that case. So, plaintiff's argument that there was a constitutionally protected right of privacy recognized in Burnett is simply not accurate, as the New Jersey Supreme Court did not reach that constitutional question. Again, there is no case law. Plaintiff has not cited any case law that mirrors the circumstances here, where we have a brief inadvertent disclosure of Social Security numbers that was immediately corrected upon notification, and involving plaintiffs who were offered an opportunity to utilize a LifeLock service free of charge, and they did not take advantage of it.
The LifeLock, does that have anything to do with whether they stated a cause of action in here? Isn't that a mitigation of damages argument?
I was going to move on, yes, Your Honor. In terms of alleging damages for purposes of their claims, plaintiffs have not and are unable to do. They've cited to allege emotional distress damages. However, they need to prove underlying damages to begin with, as we expressed in our reply papers, which, based upon the fact that they were offered the LifeLock service and failed to take advantage of it, demonstrate they cannot demonstrate any underlying damages, which then potentially could allow them to recover emotional distress damages. But again, they have to prove the concrete harm in the first place before they can even be considered for potential emotional distress damages. Plaintiffs have not argued any concrete harm in this case. They argue speculation and nothing concrete in terms of identity theft that's occurred, charges that they've incurred due to steps they've needed to take to protect their identities, like other LifeLock type services. They haven't made those allegations. Their complaint, I believe, says potential harm. So they wouldn't be entitled to emotional distress damages. So we submit that they do not submit any allegations or cognizable claim that they've suffered any damages in this case, which further demonstrates that the New Jersey civil rights claim is ripe for dismissal.
Mr. Barry?
Thank you, Your Honor. Respectfully, I think the whole of really the argument here on, or I suppose the balance of a lot of these issues about damages, proofs, length of time are wholly irrelevant to whether or not there's a prima facie constitutional claim alleged. I think that it is quite clear, based on the cases cited in New Jersey, courts have long recognized a broader privacy constitutional right than the federal counterpart. I agree that there's not a specific case on point in New Jersey's jurisprudence on this issue, but I also think that the Warner case and the cases cited there do make out that there is indeed a protected interest in privacy information, such as Social Security numbers and other sensitive information. I think what's really being argued here is that plaintiffs aren't going to be able to make out the proof requirements substantively, and I'm sure at some point there will be dispositive motion practice on that issue, but I don't believe that's the case. I think I will only note that I do agree with defense counsel. Warner does stand for the proposition that one of the prima facie elements of this type of claim is some culpability beyond the level of negligence. We led beyond the level of negligence, egregious conduct to the level of shocking the conscience. Because I agree that's the prima facie elements. Will we be successful in demonstrating those elements after discovery? Well, I certainly think so, but that's why we have a litigation judge. I think it's definitively clear there is a protected privacy interest. Plaintiffs have led an adequate prima facie case. I think the arguments or issues here are really more summary judgment issues, and I will note only that it is important to recognize there's also an injunctive claim here that is part and parcel, but also separate from some of these damages issues that have been raised. So, subject to any specific questions by the court, that's what I would say on the constitutional claim against the city in this matter.
Anything further?
Yes, Your Honor. As plaintiff's counsel cited to the Warner case, he said that they recognize a protected interest in Social Security numbers. They did not recognize a constitutionally protected right to privacy based upon the negligent, inadvertent disclosure of Social Security numbers. The New Jersey Civil Rights Claims Act requires a constitutionally protected right to be identified. So this is not a fact issue. This is not an issue for summary judgment. This is a legal issue, whether based upon the specific circumstances here. I'm not saying there's no right to privacy in all circumstances. We're talking about the particular circumstance here where there's a temporary, inadvertent disclosure of Social Security numbers. We're not talking about Burnett, where they're looking for millions of documents, including millions of Social Security numbers. We're talking about a limited situation here.
Does it matter if it's inadvertent or purposeful, or willful, or wanton, or reckless? Does it make a difference? Because you keep prefacing everything with it's an inadvertent temporary. I get it's temporary, although it was taken down. Once it's up, who knows if it's out there forever. But if it is inadvertent, and he's not saying it's inadvertent. His complaint doesn't say it's inadvertent. Okay, is there a difference in your argument if it's not inadvertent? if the plaintiff proves that it's more than inadvertence, that it is willful, wanton, or reckless, does that change your position here? Doesn't it?
Well, Your Honor, the complaint doesn't allege any specific facts that it was intentional. They're basically making legal conclusions that there was intentional conduct here. They've identified no specific facts as required by the Printing Mart Morristown case to sort of support a claim that it was intentional or reckless or willful or wanton. And I would say that to the extent they did, which as I mentioned, they did not, the facts in this circumstance demonstrate that they cannot prove that claim based upon the circumstances and the progression of events which occurred here. It's our position that the right to privacy is not implicated based upon the specific facts here. Plaintiffs have not identified any authorities that suggest it is. We have identified authorities that state a right of private, constitutionally right of privacy is not implicated. So we believe that there's no basis for a claim under the New Jersey Civil Rights Act. And similarly, the discount of the complaint is right for dismissal.
All right. Gentlemen, thank you. It was well argued. I am not going to give you my decision from the bench because I want to reread Burnett. I will endeavor, today is Wednesday, to try to get you my memorandum of decision and an order. I'd like to say by Friday, but I'm planning on going to the State Bar convention and the ICL classes on Friday. So if I can't do it by Friday, I will try to have it to you by Monday afternoon at the latest. Okay? All I want to really do is reread Burnett. And then I'll, in light of counsel's arguments and his interpretation of Burnett, I want to reread it. All right? Thank you. Appreciate it. We're off the record. Have a great day.
Thank you.
Thank you, counsel.
Thanks.